streetlights, is that part of the CDOT Main Street Revitalization Grant, or are those two separate things? Okay. So it's four things. The streetlights aren't part of the CDOT Main Street.
Okay.
Just one?
Hi, Deanne. Okay. Jennifer, were we supposed to have any packet items for agenda item number 2? Um, okay.
If we ever want to say something, are we allowed to talk as a person or are we only allowed to talk as selectmen? You know, if some issue comes up that we care a lot about, can we talk as a citizen, or do we, because we're in an official capacity, do we have to?
I don't see any reason why you shouldn't speak as a citizen. And maybe Jerry can give us some advice on this, but I think it would be important to make sure that you,
That it's really clear. Yeah,
right,
with capacity. Yeah.
exactly. So, you'd probably say something like, I'm stepping aside of my,
Right.
my selectman position and speaking as a citizen right now.
Okay.
Kent, were you in on the question? Okay.
My computer was coming up.
Okay. Deanne has a question. So,
If something comes up where I have a comment I want to make, but I want to make it as just a normal person, a citizen, rather than having any kind of official capacity, is that allowed? Or if we're at a meeting
Sure.
like this, are we always selectmen because we're selectmen? You know, I mean,
Well, people always view you as selectman,
yeah,
but you can say that I'm saying this as a private individual instead of as a board member.
okay,
And, and just leave it at that. If the shorter and sweeter that you say it,
yeah,
unless it's a really inflammatory topic, the shorter and sweeter, just saying, I'm just stating this as
yeah.
a private citizen. People do that every once in a while.
Okay, I didn't recall seeing anybody do anything like that, so I thought I'd ask before it ever comes up in real world time, you know.
Yeah. I mean, Mary Smith has said it every once in a while, and John, I think, said it very rarely, and it's a very rare topic that they will,
Yeah. Okie dokie, thank you.
I'm trying to get different actions that help communicate, because a lot of times I end up speaking over somebody else. So, and I got to go upstairs for the flag.
before you go though, I mean,
Yes.
we're getting close, but I just sent you an email because, I had asked Jennifer, but I think she must have stepped away from her desk. I didn't see anything in our packets for agenda item number 2.
I don't think we had really much of anything.
Okay, okay,
The judge just wanted to say some things and
okay. It just,
present.
when it says motion for approval or
Oh,
denial,
yeah. I'm sorry about that. I didn't
then
catch that.
I wondered if it
That's
was,
the default that Jen uses, and then
it's just an info item.
I didn't catch it. Yeah.
No worries. Okay.
And then she told you about some more staff stuff.
Mhm.
Okay.
Yep.
It's more an all around staff thing tonight. Which reminds me, I gotta make sure I have up the right email so I can share my screen if need be.
Okay.
And Mary did hear from Keith today, and he's back, and he's heading back out to Wichita, but he's back in. He made it back here for at least a little bit. So.
Okay. 4.
Hello, Lynette.
Hello there, Jerry. How are you?
Good. It's raining down here in Evergreen. What's it doing in Georgetown? I bet it's snowing by now.
Actually, it tried to spit some snow earlier and then it kind of turned to rain and then it quit for a while. So,
Well, it's important to get this last blast of snow to remind us never to plant the pansies until Memorial Day. I've been caught
at
any
the
number of
very
times.
earliest, yeah.
At the very earliest, yeah. I lived in Alma, Colorado. My first house was in Alma, Colorado at 10,400 feet.
Whew.
And, it would snow. I bought the house in July, and on August the 15th, it snowed. And I thought to myself, my God, what have I done? I was 28 years old and didn't realize that, it was going to be okay. But it snowed until the next June. So I had July for a snow-free month up there. I never planted any pansies in Alma. What's the point? What's the point?
Oh, come on, peeps. Hi, Donna. Hi there, John.
Hi, John. Where's your cat? Or should I have asked?
Zoom will be here soon.
That's the name of your cat?
No.
Well, it works. How
It's
y'all
good.
guys doing?
Very
Oh,
good.
look at that.
Oh,
Dog.
here's
Yeah,
here's
cat there.
Donna's kitty.
That's my secretary.
Important.
Need more Brady Bunch squares from the Brady Bunch.
Yep. There's Rob. And Paul. Jennifer, are you trying to get people in, or is anybody waiting?
No, I'm keeping an eye on it, and
Okay.
everybody, there's nobody that's an attendee.
Okay, and we're recording, so I'm gonna go ahead and get us started. It is 6:01 PM on Tuesday, April 27th, 2021. And I would like to call the meeting of the Georgetown Board of Selectmen to order. Please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Roll call is next. I am Lynette Kelsey, Police Judge. Rob Connell.
Here.
Deanne Powell. You have to unmute and say, yeah.
Yep, here.
Thank you. John Jennings.
Here.
Paul Hinton.
Right here.
And Mary Smith just joined us. As soon as she gets unmuted, she can.
I'm here.
Thank you very much. Okay, we have a quorum. Next is agenda approval, and Kent has several items to add under staff items. Do you want to list them, Kent, or? He's
almost back in his
Okay.
office. He's
All right.
moments away. I think he's there now.
Okay,
Let's just give him a sec.
sure.
Yeah.
Hi, Kent.
Street lights. Hi there. Strauss Park tree and capstone project and CDOT Main Street revitalization.
Okay, and the
Something.
streetlights. Anybody else have anything to add to the agenda? All right, would anybody like to make a motion to approve the agenda as amended?
I'll make
a
that motion.
Okay, Rob, go ahead. I'll second.
Been moved and seconded to approve the agenda as amended, and all in favor say aye.
Aye.
Any
Hi.
opposed? Motion passes. Audience business. Members of the audience have 5 minutes to present any matter of interest not already on the agenda. And if you'd like to present something, please type something in the chat so that Jennifer can promote you. And we'll wait a moment. And seeing none, we will move on. The payables that we have in our packet are from April 9th through April 22nd, 2021. Any questions or comments for Kent or Mary Sims?
I have something that's probably you guys already know, but I noticed that the insurance company was down in several spots. I'm assuming that's just for clarity about the particular thing they're covering, but is there a place where all of it is put together so that there's one amount someplace that was paid out to the insurance company?
It is separated by fund. So depending on what we are paying, we usually pay the property and liability insurance in the first week of January for the whole year. These are just supplements, like we got a new Parks and Rec truck, so I believe that that's what that bill is for. But there's not one place, it's spread among the different funds.
Okay. Any further questions or comments on the payables?
I'll entertain a motion to approve the payables dated 4/9/2021 to 4/22/2021.
I'll entertain the motion if you'd like to make the motion.
I'll make that motion.
Awesome. Second.
It's been moved and seconded to approve the payables from April 9th to April 22nd, 2021 as presented. All in favor say aye.
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 Any opposed? Motion passes. Next, we have the minutes from our April 13th, 2021 meeting. It was a regular meeting. Any comments or corrections?
I found some typos that need attention. On page 4, in the third paragraph from the top, bottom sentence of that, there's a place where it's supposed to be the word B, B-E, but it's only the letter B. And,
Okay, slow down.
oh,
Where was that?
page 4,
Yeah,
3rd paragraph down, big fat paragraph. It says the geotechnical consultant and field personnel must, and then
The last sentence of that paragraph.
okay.
should
Wow.
be B instead of just the letter B, unless we're doing chat speak now.
Okay,
The other thing is there are 2 page 6s. So our numbering is off. The first page 6 is the one that's supposed to be 6, but the second one should be 7, which means everybody after that should be one number higher.
Yeah.
And on that page, the first page 6, there's a paragraph second from bottom, begins with the word Craig Abrahamson, civil engineer. About 2 sentences in, it says installing 3 manholes from 10th Street to 9th Street, Main Street. So there's some little word left out of there, like maybe.
Okay, so that should be on Main Street. I think.
Okay. And then on, ready for the next one? I'm horrible like
Yeah.
this. I like being.
Yeah, go ahead.
And, anyway, on page 9, there's a list of specifications in the move that was the motion that was made. In number 4, it says applicant to construct a segment of the Plains to Prairie Trail and its peak to Plains. Unless there's some different one. See? Stripe.
Was that
Okay,
all?
got that. Add peak and peak to Plains, or peak to Plains Trail, I see.
Delete Prairie, yeah.
Yeah. Got it.
That's all the typo-y kind of things I found.
Anybody else?
There was one more on page 8.
Cool.
The last sentence in the bold motion where Selectman Smith provided the second, 5 were in favor. I believe only 4 of us were in favor since Lynette, you weren't voting, correct?
Correct.
Because we're only a board of 5 right now.
Yeah.
Okay.
Okay.
That's it. That's all I had. Well,
Okay, and then I had some, and this was on, well, it's labeled page 9, should be page 10, is where it starts, the proposed easement agreement for the driveway access. The claim name is Arctic, not the, and then MS is not really part of the claim name.
Okay.
So, in its actual legal description, it also refers to lot 6, I believe, wasn't it, Jennifer, of the Starrett Division of Land?
Yeah.
So, so wherever the word Arctic appears, probably should correct that. And also Jennifer said she got it from a written paragraph from Craig Abrahamson, but the direction of that easement, if you've got the north arrow going in the correct direction and you start at Skyline, the easement runs east northeast, not east southeast.
Okay.
And then on the top of page, what's labeled 10 should be 11. Second line, just add an S to proceed.
Okay.
And at the bottom of that same page, second line from the bottom, cross out the word to and then put an S after resume.
Okay.
And that is all I had. So,
Any more additions? Nothing? I'll make a motion to approve the minutes dated April 13th, 2021 with the aforementioned corrections.
I'll second.
it's been moved and seconded to approve the minutes of the April 13th, 2021 meeting with the mentioned corrections. Any further discussion? All in favor say aye.
Aye.
Any opposed? Wonderful. First on our agenda, we have Donna Klein here to make a request on behalf of the Clear Creek County Mayors and Commissioners Youth Award. Donna, welcome.
Hi. Thank you. It looks like there's some new members. I actually read in the newspaper where you have some new selectmen who probably aren't familiar with the program. It's been around for probably 30 years. We used to be part of the Metropolitan Mayors and Commissioners Youth Award. And the program was the big 10 counties plus Gilpin and Clear Creek and Park, I believe, was in it, and Boulder. they disbanded because it got so expensive to have the function that the kids weren't really getting anything but a $50 gift certificate. And so it seemed kind of like they were raising money and people were paying dues just to have a dinner. So they said, feel free to use the name if you want. And our commissioner said, of course we will. The other thing that they used to do kind of made it like a contest, and Clear Creek was never comfortable with this. It seemed like it was a contest of who had the worst adversity, and they got to go to the dinner. Although we generally put 4 to 5 people in our group, we had a little, tea with the commissioner kind of thing and stuff like that. So when we went on our own about, I'll bet it's been 12 years or so, that's when we decided we could do it bigger and better by keeping it very local. We have our dinner at Easter Seals. They are very generous with us. And we give them a laptop, a printer, a $500 scholarship to any higher education that they want to go to, whether it's VOTEC school, college, community college, whatever they want to do. We will write that check for them when they're ready. It's open to any child 13 to 19 years old. They don't have to attend public school. I think everybody's really clear on homeschooling this year. And so they keep track of kids all over the county. They're recommended by counselors who help them, or teachers, or anybody in the community is welcome to nominate a child. We have 7 kids this year, and they are exceptional kids. They have done very well, having lived through their diversity or living with it, or adversity or living with it. And they always seem to excel in school, in community. If you look at the application, they have to perform community service or be in a club or do something that benefits their community or their family. And all these kids just, I don't know, I just find it the most uplifting, positive experience of the whole year. I do a few things for the Department of Human Services, and this is far and away my favorite program that I do. I always look forward to it. By the end of the year, I send out the applications, and by this time, I'm usually in tears from reading the stories and then writing their positive story. The nominator writes the whole story about the adversity. We never, ever focus on that. We focus at the dinner on what they're doing positive in their lives now, what their plans are for the future. We have 1 8th grader this year, 3 seniors, 2 juniors, and 1 sophomore. None of which this year are from Georgetown. We have 3 from Idaho Springs. We have 3 from the unincorporated areas of the county, which it's all evergreen. And we have 1 young lady who had to move to the Denver area. She's a senior. She wants to graduate with her class this year up here. So she has driven up to school every single day. And while she's on her way, she drops her younger siblings off at their school, which I assume is Carlson. And so everybody is still a Clear Creek County student. That's determination. And that's pretty much what these kids have. They have determination. Their lives haven't been easy. So what I do, the county believes in this program enough that they give me a little budget. And then they say, it would be nice if I could supplement that budget. And so I go to Idaho Springs and ask them to help me supplement that budget. And I come to Georgetown and Empire and Silver Plume if they can. They don't quite have the incomes that you and Idaho Springs have, but they have donated. We never ever ask for a certain dollar amount. We just leave it up to the goodness of your heart. So that's my presentation.
Thank you, Donna, very much. It's an awesome program. I've been attending the award ceremony for the past 2 years, and it's very moving. I actually attended one before when I was pro tem, so
Yeah.
3, and coming for 3. So, and in the past years, we have approved a donation of $500, which unless I would like to recommend to the board that we do that again. So any comments or questions from the board? I see some thumbs up. So who would like to make that motion?
Make that
I'll make
motion.
Fine. I'll second.
Okay.
I move to approve the donation of the amount of $500 to the Mayor's and Commissioners Youth Award.
All
Second.
right. It's been moved and seconded to make a donation of $500 to the Mayor's and Commissioners Youth Award. All in favor say aye.
Aye.
Any opposed? Motion passes. Thank you very much, Donna.
Thank you very much. We really appreciate it. I know the kids appreciate it. It is emotional there, and their eyes just light up when they see how much the people of Clear Creek believe in them.
Mhm.
And so it's always rewarding. So thank you.
Thanks very much.
Mhm.
Okay. Item 2 on our agenda is some information from our municipal judge, Judge Toussaint. Welcome to the meeting. You're muted. Yep.
Sorry, thank you very much, yes. All right, well, for those of you who've been on the board for many years, know that me as your judge for the last 26 years really only showed up to talk to you as things of import occur. And in the last few years, more and more of that has happened. And if you remember, it was just last December, Judge Elliott and I both showed up to discuss a number of issues. And for the last 4 or 5 years, I've been appearing pretty regularly and we're talking with Harold Dahl about the many attacks on the municipal court system, mostly by the legislature, also in the courts by the ACLU. And there's been a lot of changes in the last 5 years, much more so in the first than all the first 20 years I served. And so things are changing, and not necessarily for the better. Maybe, I guess that's debatable. Is it better for society in some ways? Maybe, but for the operations of municipal courts and what we're trying to get done as a gateway into the judicial system, I don't think it necessarily is better. But that's for you all to decide and how we go forward. But today I've got some good news and some bad news, and we're going to go through it briefly. One of the new issues that we have, and Judge Elliott is out of town, or he would be here this evening. He's working on a community service program where people who cannot afford to pay fines and costs, and this would not include restitution, which I'll get to in a minute, but to pay fine and costs, can do community service work. We used to do that quite a bit, but it got very expensive because just to sign up through the county system to get the insurance, we'd be able to do a lot of these different programs was nearly as much as most of the fines that people were trying to not have to pay because they couldn't afford them. So it's kind of fallen away, but we are now resurrecting that, and we are finding not-for-profits that accept volunteers anyhow, and therefore don't need to go through the county insurance program for workers' comp. So we are pushing forward with that. It'll be the visitor center and the high school, the old high school. Is it called the Heritage Center? Is that what we call the? Yeah. Okay. And other projects like that. And so Tom's going to be working on that, and Bettina, I think, is already helping him on that. We've got a new form that's going to be filled out, and it's something that we need to be able to provide for people who cannot afford their fines. I don't think it's something that we need to do across the board, and I'm not sure in many cases it's the right way to go, but in some cases it's constitutionally and statutorily mandated. So we do want to have that tool in our toolbox, and we're putting it back in there. So second, as you've heard me in the past say that under statutes, we are required to have an attorney for, including court-appointed attorneys, available for everybody who's in jail for their first court appearance. Now, that has not, and if you remember some years ago, I came and asked for a budget of, I don't remember, $350 or $500, somewhere in that area, so that we could take care of this when it became a problem. We have dealt with it on the way we deal with our warrants, so that anyone who is arrested is given a bond that it's called a personal recognizance bond. And they can just sign out and say, I understand I'm supposed to be in the Georgetown Municipal Court on such and such a day at such and such a time, and I promise to be there. And then they're allowed out of jail. Well, unless they're being held on other people's charges. But for us, we no longer put a hold on them. So no one appears in our jail, in our court while they're still in jail. That doesn't happen. So we don't have to apply our having an attorney present for anyone who's incarcerated. And that's why you have seen billing for court-appointed attorneys for that. However, there are other reasons you have to have court-appointed attorneys. And even Empire, who has decriminalized all of their ordinances and traffic so that they cannot actually face jail there, still has to provide attorneys, court-appointed attorneys for people who cannot afford one. If in county court, they could face jail time for the same charge. And therefore, if I get arrested for careless driving or something like that, even if it's been decriminalized in Georgetown or in Empire or in any other town, because if that person had been pulled over by a sheriff or police officer who rode at the county court, they could face jail time and therefore could be entitled to a court-appointed attorney. That this could still be a situation where they would still be entitled to one here. So it hasn't come up, but it could come up, and we haven't decriminalized everything. In fact, there are many issues that are still criminal penalties that could result in our having or that the defendant has to face jail time and would have to if they went to trial, maybe, depending on their financial circumstances, be entitled to a court-appointed attorney. Again, that hasn't come out. We try and work with people, and that is our approach in this situation, so that people are not faced with going to jail if we can work out some resolution that works for the town and works for the defendant. But if when I appeared before, I did not make it clear, I am requesting now that we have a line item in the budget for future years of at least $500 for court-appointed attorney time. Now, when would they be eligible for this? Well, first of all, they have to be eligible financially, and that's a pretty low bar. I mean, you basically have to be out of work to be eligible for and have, ongoing bills that you have to pay, things like that, to be available for either a public defender, or in case of towns like us, it is a Office of the Alternate Defense Counsel who provides the attorneys or could provide the attorneys for us. So that being the case, we do need to be ready to have to appoint an attorney for this. I did some research on this by going through, Bettina and I both have been working with the Office of Alternative Defense Counsel, who does provide a list of attorneys who are been vetted and are approved for who are approved to do defense counsel. So hang on a minute. Mary Sims, do you have a question? Your hand's up. Maybe.
I just wanted to make sure that you did know we do have funding in the municipal court budget for such attorneys. So
Good.
that was put in, I think it was put in last year, actually. So it's in last year's budget, and it was in last year's and this year's. So just wanted to let you know.
Good. Well, thank you. And I think that's great. And just so people, and how much is that, Mary, offhand? Do you know?
I'd have to look. Bettina and Jen and I looked at it like a week or two ago. I want to say it's 500 or 1,000.
Okay. And that's where we want to be, because I was going through the list of eligible counsel that we could appoint from the list from the Office of Alternate Defense Counsel. And I found a name that I recognize as an attorney that I've known for a long time and who I respect. And he, the Office of Alternative Defense Counsel, does pay between $75 and $80. He charges $80 per hour for this. As those of you with private counsel of your own, or paying other lawyers, water attorneys, Mr. Dahl, whoever, that attorneys are generally charging a lot more than that. But that's not necessarily case in these situations. And this attorney, by the way, and Jerry, I don't know if you know him, it's Fred Bibick. Yeah, okay. Fred's been doing Jefferson County. He was one of the chief deputy trial attorneys for Jefferson County for many years, kind of retired from that, and now is doing this out of a private practice. And by the way, he is interested in working for Georgetown because his office is in Lakewood, and there aren't many vetted attorneys who are in Lakewood. So he's probably going to be one that we're going to be looking at as somebody, especially with his credentials, I think it'd be good. But I want you to know that we will be, when we're requested to appoint someone an attorney because someone cannot afford an attorney, we do a vetting. There's a Supreme Court guideline that we look at, and once they meet the criteria, then an attorney will be appointed for them. They meet with that attorney, and we go forward with the case. Fred told me, just so you know, that it's about $250 per case. So $500 gets us a couple of cases. If we have to go to trial, though, it's going to be more, and we could run through that $500. So just, I'm just trying to give you a heads up. On the other hand, I've been here 26 years, and we've never had to appoint one. Been close a couple of times, but for whatever reason, the situation resolved itself. So it hasn't happened, but I do want you to know that that is still going forward, and it may be a budget item that we will have to be utilizing in the municipal court budget. There's a number of standing policies for Georgetown Court, two of which I just developed over the years because of problems that we've had. One is plea bargains after a certain date. In cases of a jury trial, it's 7 days prior to the jury trial. There are no more plea bargains. They either go to trial or they plead guilty at that time. If we're going to bring in up to 24 Georgetown citizens to be in a jury pool, we're not going to do that and then have somebody go, "Oh, just kidding, I'm going to, plead guilty now." And that's just not going to happen. And so that's been one that's been ongoing. There was a little snafu on that in the last couple months, so I'm making another written order, that standing order of that procedure. And then the other one is and we've discussed this with the board before, which is people exceeding speed limit by 25 miles an hour. The only plea bargain that we allow in those situations is that they can reduce the speed limit from over 25 to 20 to 24 miles an hour. It's still a 6-point ticket. And but there is no jail time attached to that one. And so we don't get into the whole problem of attorneys and court-appointed attorneys and things like that. So that is the one plea bargain that I will have. Otherwise, no, they're either going to plead guilty or they're going to go to jail. I'm sorry, they're going to go to trial. They may go to jail too, but probably not. All right. And then there are a number of others, standing policies that have to do with sealing of records and expungement of records and things like that, that we've worked with Jerry a number of years ago, and I'm going to update all those. And I'm glad to see Bettina on here, so she's now forewarned that she's going to be working with me on this a little bit. So that's another thing that's going forward. Then the Colorado Municipal Judges Association, which you all know, both Tom and I are members of, and about 5 years ago, when all of the new legislation about municipal courts erupted, they hired a lobbyist, and it's the same lobbyist that the Colorado sheriffs use, and they're very good. You all, as members of Colorado Municipal League, I assume you are, also have a lobbyist. But the courts, because of the many issues that are very specific to courts, have hired this person or this group rather, and they are doing a great job. If there's ever any extra money in the municipal court budget, I would like to suggest a contribution be made to the Colorado Municipal Judges Association lobbying efforts, because it's just being made up by, mostly the larger cities, Aurora, Denver, Fort Collins, Lakewood, are paying the freight on that. But these guys are doing a good job and really trying to keep bad statutes from becoming law. And we've got a bad one I'm going to talk about next. It's a nice segue. There are two proposed bills that are pending that are very troublesome and which we're lobbying against. I just got an email while I was getting prepared for this that the House Bill 1175, and I don't know if any of you have followed that, has been moved out of committee. This one was one of those things that was so far out in left field, no one thought that it was going to go anywhere. And the fact that it's moved out of committee is kind of scary. So let me tell you a little bit about it. It was originally sold to help folks who couldn't pay their fines. And we talked about that with like community service or something like that. But most courts, including ours, have always had programs which we could do, and which we're now, as I said, adding community service back into the what we can do. Can help people who can't pay their fines. So that's already state law, that we cannot punish anyone with jail or contempt or anything like that if they are unable to pay their fine without an undue harsh burden to themselves or their families. But this bill has now morphed into a bill that basically will help wealthy people by giving them a tax break. So we've gone from helping poor people who couldn't afford it to basically creating a new tax break for people. And it's going to cost the municipal courts a lot of work and tracking of defendants. And again, Bettina, I hope you're paying attention, because you and I need to figure out how much additional work this could end up costing us. What it allows is that every defendant who gets a fine from the municipal court can now choose to make a donation to a not-for-profit for their traffic violation, for both their costs and their fine. So the town gets no revenue at all, and we have to now, if we're doing our job, and I think we want to continue to do our job, we have to track what they do. So they have to go fill out a form with us, then go and make the donation. Then we have to somehow get information back from the not-for-profit. It could be, the Smith Foundation. Who knows what the Smith Foundation is or what it does or anything like that. It isn't like it's the local library in Georgetown. It is definitely just any not-for-profit, and that's the tax break. In addition, the donations can be either money, which has its implications, or time. So now, how is our court, basically Bettina, supposed to track multiple defendants and their time at a certain rate, which would probably be the minimum wage of $12 an hour in Colorado, or we could set it at whatever, but that's basically what we would set it at, I would assume. So at $12 an hour, they got a $350 ticket plus some surcharges. Who's going to track all that, and how for all those hours? I mean, you're talking about somebody's having to come up with a tracking of 30 hours of time on that, and how many months, and it's a that's just a huge amount court administrative time that we don't have it in. I'm pretty sure it's not in the budget right now, is what I'm saying. And I want to find out from Bettina and also from Jennifer how much time they think that's going to be to track that, because we have to track it sometimes when people make payments over several months because they can't afford it, or people who do have done certain classes over a certain amount of times, they have to track those and things like that. But what's it going to be if almost every defendant goes, well, I'd much rather give it to, the Smith Foundation charity, which I like, than Georgetown, which is, fining me. So it's going to have that negative impact on the court system in terms of additional administrative time and the amount of revenue that would be flowing from the court. And Georgetown has never looked at the court system as a revenue making thing. They don't set out radar on the highway and this and that. They just enforce the laws fairly. Well, I'm going to tell you that that revenue that kind of helps pay some salaries and the costs of running a court system is going to probably dry up. And so that's pretty amazing, a negative factor that could have an amazing consequence to you guys. In addition, there is no judicial discretion. So if somebody comes in and says, well, yeah, I'm really got an attitude towards Georgetown and I'm just not going to pay this, I'm going to do it. And then they give us, no reason for it. And it's no longer a, well, I can't afford to pay it situation. I can't stop them and say, no, you're going to pay. I have no discretion over that. So that's a pretty serious one. And then that one got moved out. Everyone thought it was so far out in left field that no one thought it was going to move, but it's gotten some legs and it's moving. And Ken, I don't know if you're in touch with the CML people, but if you are, please have them do this. And Jerry, you too. I mean, if you guys are talking to other cities and court systems, please, make sure everybody's aware of this one. We've got to, it's just a goofy thing that one legislator has come up with, but somehow it's gaining ground. So I really do want everyone to be aware of that. The other thing is Senate Bill 62, which is for the first time creating arrest standards. And this is kind of coming out of some of the protests last summer and discontent with people have with policing and stuff like this, and maybe in some ways aim more at law enforcement than the courts, but it's got some serious consequences for towns. And one, the towns would no longer be able to arrest under municipal ordinances. Well, we've got some serious things under your municipal ordinances. So it isn't all just barking dogs and things. You guys have theft, you have drugs, you have minors in possession, you have lots of different things that are important and may need the consequence, or at least the threat of the consequence of some jail time or something like that. Well, your police officers, and Marshall, I know you're paying attention to this, but the arrests would no longer be legal from under our municipal ordinances. In addition, there'd be no bonds. Now, I already mentioned earlier that we don't really use bonds much. We do the what some cities refer to as catch and release. You arrest them, give them a personal recognizance bond, and then they're released. But they've had to, be arrested, taken to jail, fingerprinted, photographed, fill out the forms, and then and then are released. So it is a process, and they understand that while they didn't have to pay any money to get out of jail, they certainly spent some time and inconvenience getting out of jail. Each defendant in each case will be given, and I think there may be an amendment to this one that's been offered, and I have not had time to study it, but it was 3 failure to appears in each case. So I cannot show up for 3 different court dates. Well, that's pretty bad right there, because if they don't show up, we have a hard time, keeping track of defendants 90 days, 100 days, 120 days away. And so, they can miss 3 court appearances and not face any consequences. Also, victims of crime are not being heard in this at all, and they're not being protected in cases of violence against a person. And your ordinances and what your police officers do does protect victims as well as the general population. And also businesses that have been hurt by criminal action are also not being heard with regard to getting restitution back. So I said I'd mention in restitution later on. Well, that's the mention, is that they're trying to slow these down. So those are the 2 bad bills this time. There have been some other ones. Our lobbyists have worked with the sponsors and have gotten pretty good results, and we're able to live with those. But these are, pretty far field in our opinion, and the Board of Selectmen need to be aware of this, because it's going to have, long-term consequences on your court system and the court's budget. So that's my report. And I know I was just here 4 months ago, but here I am again. And I just wanted to give everybody an update.
Thank you. Jerry, did you have anything to add?
No, I've worked with the 2 judges and Bettina on some procedures to streamline things in terms of prosecution. Not something that we need to trouble the board with. That's just administrative on the court side. And I've worked with the prosecutor cooperatively. We expect to continue to do that. So no more of a report than that.
Okay, thank you. Marshall Williams, any comments?
Not particularly. We're on top of knowing about all of this. Senate Bill 62, the Jail Reform Act, and all the rest of the problems we have. For a long period of time, we've already used our discretion if we're going to charge somebody into municipal court. And if it's something where there should be more teeth to the charge, we go ahead and just skip over that and move to state courts. When we think we've had a lot of occasions where we don't want to do that to the people, citizens, whatever else you might want to call it, that we're dealing with, then we put them into the municipal court and try and work it out there. Sometimes it works, it's beneficial, and other times it bites us in places. So, but there's nothing the Judge Toussaint presented that was a newsflash. Unfortunately, we are in strange times here, and it doesn't seem to be getting better any faster.
Okay. All right. Thanks very much, and thanks for your report. And we'll continue to monitor, and let us know if it doesn't seem that those 2 bills are being defeated.
Opposed? Okay,
Thank you.
I think there's a
Um,
question.
Any questions from the board? Yes, Deanne.
What are the good possibilities? This seems so blatantly obvious that it's not gonna work. What, how can it be passing through? What is positive about either of those two bills?
Well, the sheriffs believe that the Senate Bill 62 is kind of just a knee-jerk reaction to the anti-policing issues, and maybe Marshall can respond to that better than I can. But that seems to be where the legs came from. That would you agree with that, Randy?
Definitely the anti-police year that we've had, at least starting in May. Up until May, the police were heroes. After May, 800,000 people who do a job are all evil based on the acts of a few. Definitely, it's been leading in this direction, and now with the single party government in the state, it just seems to be flowing easily. Some of this is state specific, some of this is going nationally. They're finding it doesn't work. The jail reform doesn't work. Sometimes jail is a necessary step to help break a pattern. But we're just going to see what happens. So as far as what the benefit is, there's a lot of benefit to a certain demographic, but beyond that, to citizens, I don't see a lot of benefit.
So I would agree with what he's saying. I think there's a lot of, it's national and it isn't just here. And a lot of these are not just being pushed by certain groups and legislatures, but also heavily by the ACLU. And so, and they carry a pretty big stick because they constantly take states, cities, anybody to court, and that can be expensive. And so people try and work with them, even when it sometimes seems counterintuitive. So that's one of the things. As far as House Bill 1175, Ms. Powell, I'm sorry, I don't, like I said, it was considered initially kind of a joke when it came in. No one thought it had any real merit, because who's benefiting by this thing that anybody could just use it and get a tax write-off? Well, at some point you're going to take speeding tickets just so you get the tax write-off. I mean, seriously, there's that aspect, and that's pretty absurd. I don't know. And I was in a conference Thursday and Friday of last week, and in that conference, the lobbyists for our association did speak, and they really had hopes at that point, as of Friday, that it was not going to get voted out of committee, but it did get out today. So I don't know who's really, it doesn't, I mean, for those of us, I'm going to separate us from the municipal area, the metro area down below, and those of us up here in the hills. I haven't found anybody who, when I talk to them about this, that can tell me what the logic would be and why anyone would want to support it. So I don't know if it's a city country thing or what it is, but something's happening. So I can't answer your question, really.
Just a quick question. Our points are still assigned though on the driver's license, even though they have the opportunity to pay the fine in a different manner, correct?
That is true, yes.
Okay.
But that is becoming the only thing, because one of the issues that keeps coming up, didn't come up this year because of the interrupted session due to COVID. They did not bring up the bill where they're going to take away our ability to put a hold on their driver's license. And that is, since we can't issue warrants anymore for failure to pay fines and costs and restitution, we now are in traffic cases at least limited to the default under a outstanding judgment warrant, which is handled by DMV, and the same people put your points on. Courts don't put points on, the DMV does that.
If it's passed, is it unethical if we give them a list of Clear Creek County nonprofits?
No, it would not be unethical at all. And that might be a really good idea, Mary.
I mean, at least that way it stays within the county and helps somebody. I don't care if it's Charlie's place, if it's, if it ends up being, an option that people seem to go for. I don't like it, but I'm just wondering if there isn't a way we can't make some kind of lemonade out of the lemons.
Well, and I agree. The other thing would be is if it's our local ones, it would probably make Bettina's job a lot easier, because she could just call up somebody she knows over there and says, oh, did Jack Jones complete his time or pay his money over there or whatever? And they say yes, no, indifferent, whatever. But if it's, using my example before, the Jones Foundation, who, how are we going to find that? How are we going to know? I mean, it's going to be an issue. It's going to be a lot of administrative work.
Any other questions from the board? Okay, seeing none, we will move on. Thanks very much for your presentation.
All right, I'm going to duck out if that's all right.
Thanks.
Thank you. Bye-bye.
All right, agenda item number 3 is our easement agreement for a driveway access for Justin and Leisha Scott.
I'm the staff report on this item. Members of the board, you saw this issue, or was brought before you a couple of times, and most recently, I think, last meeting. And during that meeting, you directed Mr. Brown and I to prepare an easement agreement for this driveway, and we have done that. You had indicated a number of things you wanted to make sure were in the easement. There'd be maintenance of the easement, meet the guidelines, talking about whether or not a gate should be required or allowed, and a reverter back to the town if the easement failed to be used or was abandoned. And so we've created that easement agreement. It's in your packet, and I would like to draw your attention to it in 2 ways. First, the one thing that did not come up in our discussion of the board was, okay, how wide is this easement? Typically, we see driveway easements or any kind of roadway easements being articulated as a width. And in this case, I left it blank. You'll notice that there is an exhibit which shows the driveway profile that Mr. Abrahamson, who I see is on the call, prepared. And so there's a couple different ways to do it. We could say an easement. You'll see I've left the blank there, and that might be something, once you've heard from me, I'd appreciate probably if you heard from Mr. Abrahamson, and I think the Scotts, if I saw it right, were on the line, or even if they aren't, I think Craig could probably help us understand what's the width we'll need here. Not only the drive width, but obviously there's some cut and fill that will be needed to fully accommodate the driveway profile that Craig has put together, that I believe we did confirm does comply with our driveway grade requirements. I think Kent had done that. So I wanted to kind of make that note, and we'll hand over to Craig in a minute to opine on that. But the other thing that I want to point out to you is the conditions on the use of the easement. That would be on the 2nd page of this easement document, because that's where the real action is in terms of the protections of the town's property. This is an easement across town-owned property. And so there should be some conditions on it. And I believe these are all conditions that the Scots are all right with. I believe, Kent, if I'm right, this draft has been shared with the Scots in advance of the meeting. Is that true? They've seen it. So again, it's only for motor vehicle, pedestrian, and underground utility access. That's where you put utilities, usually is in the driveway. That may or may not be the case for them here, but you want to make sure the easement's available for that. That's very common. It has to meet the town requirements for construction, of course, subject to inspection and approval by the town. I think from the discussion last time, I think the board wanted it posted a private drive, no public access, for lots of good reasons, and I won't repeat those. You were there for that discussion, members of the board, but I do think that's good for the town. It's good for the owners. You don't have people showing up on your doorstep here. Letter E is just sort of a general, don't do anything that would be a nuisance on that driveway. You had specifically asked that it terminate for non-use, and I plugged that in at 1 year or more, and that's paragraph number 5. This easement will run with the land. So Scots build their house and live there for 10 years or whatever, and then move and sell the house to someone else. The easement goes with the house. It wouldn't be appropriate in any other way. If you're going to build a house and rely on the ability to get to that house, the town's going to grant that, then this easement should run with the land. And of course, all the conditions run with the land too. So the new owner is going to have to behave according to the restrictions that are here. That's my quick review here. You might want to hear from Craig in a minute on the width, but were there questions about the easement document itself from the board? I'm happy to describe those before we hand over to Craig. Questions on the easement document?
I have a question about the conditions,
Yes.
or perhaps another condition. I believe we discussed this briefly last week with the applicants, and though they assured us that their plan is that this is their permanent home and it's strictly for their use, can we implement or include a condition that does not allow this easement? Well, can we exclude the home becoming a short-term rental because the easement would allow access?
Yes, you can. This is not like a zoning matter where you're limited to things that pertain just to the proposal. It's a little it would be a little unusual, but I recall the discussion. Obviously, if you didn't put it in, they still have to get a short-term rental permit, but that program's available.
But there's a difference between the residents accessing their own home and respecting the road of Skyline Drive and their own driveway, as opposed to that becoming a potentially very desirable short-term rental and that driveway being used for more things. So that's my concern.
It's a pure policy call for the board. You have the right to do it. So if you tell me to do it, I will. Other questions? Shall we ask Craig to tell us what he thinks about a width? And Craig, can you tell me right now, it's just listed as blank feet in width. Often I see these articulated as blank feet on either side of a center line. See the drawing attached as the center line. Now the drawing you've attached, I think, functions better as a center line. So 15 feet on either side, if it's 30 feet or whatever. But I'd like you to address that if you would help me out.
You bet. Thank you. Sorry, the Scots are in their vehicle and they're having trouble maintaining their connection right now. So that's why they're not currently on the call, but I am texting with them. So if something comes up, we can try and address it. I just opened up the AutoCAD file here. If we're going to describe it as, if we're trying to describe the area to be, that could potentially be disturbed, Jerry, as part of, the overall construction, then I would use a number of, and this is a worst case, of 25 feet either side of center line. That only occurs in one location, and that's right down towards the bottom of the driveway where it takes off from Skyline. The more common circumstance it is, let's see, up here it'd be, yeah, no, that's about right. Yeah, 25 would cover it without being overly conservative.
25 feet on either side of a center line, so a total of 50.
Correct.
Understanding that that's not the built road, but you need that cut, fill, maneuvering, etc. That makes sense to me. Thank you.
Correct.
Okay. Can you give us any reaction? I assume you can text the Scotts maybe on the short-term rental issue. The board might want them to weigh in on that. Although ultimately it's the board decision on that, and it's the board's prerogative.
Sure. I'm texting with them. I'm trying to get them right now.
Okay.
I will get back to you as soon as I hear from them. I apologize.
Okay. Was there anything else in the easement document, Craig, that you wanted to note at all?
No, thank you for including the utility component, because that is the intent, is to install utilities in that roadway for obvious reasons, not the least of which is minimizing disturbance and causing us to come back for another easement.
In some other location. Fair enough.
So thank you for including that. That was an oversight on my part, and I apologize. Let me try and get with the Scotts here real quick.
Okay.
Mary, you had something else?
I don't know if Craig will be able to multitask here, and I don't know if he needs to weigh in, but I could certainly appreciate the fact that they need the 50 feet approximately for construction, utilities, everything. But once the construction is done and it reverts back to just access as a driveway, are we then minimizing the width? Because it's all done then, and we're not talking a 50-foot wide driveway at that point. I think that might also lend itself to less people trying to access it even when they see the signs. I mean, if it's something wide open, it looks like, ooh, what's this compared to a smaller, narrower trail.
Kent, I see that condition 4B requires the driveway to be constructed to meet all requirements of the town. Do we have a minimum or maximum width for driveways in town? Do we have driveway standards that would bear upon Mary's question?
I do not know that answer for $200, so I'll have to try a different quiz board to find that.
Craig might know.
Craig might.
I do. Actually, the construction standards aren't very vocal about driveways. They're very vocal about roadways, but not very vocal about driveways. So really what we've done here is we've applied basic premises from roadway standards to this driveway as it passes over town-owned property, which is completely logical. There is no limitation to the width of right-of-ways or easements for roads specifically. I completely appreciate Mary's point. And what I've seen done in the past, although maybe there's just a way of articulating this in the language, Jerry, that the 50-foot width is for construction and construction disturbance. However, the actual access and utility easement post-construction is merely the 12 feet. You would have to obviously wordsmith that the way only you can do. But that might be, that's something I've seen, and I don't remember the specific language to really limit the actual, although we do want, and this might be be a finer point. Certainly you want the grantor, I'm sorry, the grantee to have the ability to maintain the cut and fill slopes, for example, for the purposes of if there's an erosion issue, for example, that needs to be repaired, or a revegetation issue that needs to be dealt with post-construction some point down the road. You don't want to have a question as to whether or not they have the ability to do that. But I do appreciate Mary's point that you don't want to create a 50-foot swath that somebody feels like they have carte blanche to.
I think how we could address that would be to use the language of, it's 25 feet on center line to construct and maintain a driveway with a traveled width not to exceed whatever you want to say, 15 feet.
Sure.
Does that sound all right?
That sounds ideal. Does that satisfy you, Mary?
Okay.
Other questions?
I'm sorry, I'm not having any luck with the Scots here.
Any other comments from the board on the concern about this providing access for a future short-term rental? Yes, John.
I think my feeling is that it's a private property, and while we're providing an easement to it, it just should be just like everything else in town. If they want to apply for an STR, that's their business. And we can look at their access or any other things that may or may not make it appropriate for them to have one at the time.
I agree with John. This is not the place to put restrictions regarding STRs. It is private property. And if they decide to sell in the future, that's up to them. But there shouldn't be a restriction regarding STR for this easement.
Deanne or Rob, any comments or concerns?
I'm speechless.
You are. That's highly unusual.
What we could certainly do when you get to action mode, and I can help you with a motion. It could be to approve the easement agreement as presented with the our changes that I can articulate on the width.
Mm-hmm.
And then if there's a desire, Mary, to engraft a STR limitation, that could come on as a motion to amend, and we can see if it passes or fails, and that way we get Rob and others to actually have to say something about that. But that's as you well know, that's a classic technique for handling an issue that you're not sure there's consensus on, and that'd be my suggestion.
Kent, when in other documents, when we've talked about encroachments, and this is why I bring this up, encroachments aren't allowed, if I'm correct in my recollection, for short-term rental uses. And you were looking into that for something else. And this had come up, not reference to short-term rental, but it was just in the list of summaries of when we've, given them in the past. And that's, I know encroachment and easement are two separate animals. However, that's one of the reasons why I'm bringing this up. Do you have anything more clarifying that you can share on this point?
I could find it real quick to review that real quick. I want to get the exact language that was stated in there rather than being haphazard. So just give me a second. I'll find it real quick. I mean, you can go on to another question.
Sure. Personally, I would prefer that we didn't put that kind of a condition on it. I would prefer to leave the choice of whether they want to operate it as a short-term rental and just meet all of the requirements of whatever the permit requires at that time, at whatever time they decide they would like to, or future owners. I would prefer to not put that condition on the easement, but I leave that to the board. Any other comments? Yes, Deanne.
Does it tangle us up anyway because the easement is part of the town's property? Does that somehow or other get us in sync with being a short-term rental? You know, do we have any responsibility if they were to go to short-term rental? I could see it reflecting badly on us. I agree with John and Paul, however, though, that should be the domain of the short-term rental assessment rather than necessarily here in their agreement with the easement thing, the encroachment. So, but I am concerned that somehow if there was an accident on it and they were suing everybody possible, because it's the town's, even though it's given over to these guys to use as their driveway, if they change the use. And the other problem that's kind of along the same thing, number 8 says it's the intent of the parties that they and their successors and assigns will be and remain the sole beneficiaries of this, you know, and no third party. Well, sort of a short-term rental is an assign, but sort of the intent of this is for the family to do it. And so I'm seeing a couple murky places here.
Well, with respect to, does the fact that the town granted an easement somehow involve the town in the short-term rental? I would say no.
Don't have any liabilities for short-term rental stuff. Yeah.
People get access properties in all sorts of ways, and I don't think the town's easement makes that any better or worse. I do take your point though about injury, and I am remiss in not including in this, and I'm happy to do it, classic indemnification language that I usually do.
Okay,
and
that would do. Yeah.
We allow people to encroach, etc. We say, you're welcome to encroach, but you get sued, you're going to indemnify us. And I really appreciate your noting that. And when we get to motion time, I'll ask that you direct me to add the standard indemnification language that I always put on these things. Leaving us with then the kind of the policy call around short-term rental, upon which Rob is not yet opined carefully. If you like, we can do a couple of things. I see Craig is still probably trying to reach the Scots, although I also know Craig's here for the Washington Mill. If you like, we could table this item and deal with the Washington Mill resolution, if you like, although it won't take long to deal with it and then come back to it. It's up to you, Police Judge Kelsey.
Thank you. Craig's just rejoined us. So what's your preference, Craig?
I did get a hold of Scott's. They would prefer not to have that limitation in the easement, just because it seems to muddy things from a process perspective down the road. But he reiterated about 6 times by text that they have absolutely no intention of this ever being a short-term rental as long as it's in their family. So it's not a short-term problem, to be sure, for the town to be concerned with as far as the Scots are concerned. So I'll leave it at that. Okay. But it's entirely your call if you guys want to go move on with Washington Mill and then come back to this. I'm good with either.
Do we need more discussion, or are we ready to entertain a motion on this matter? Or would your preference be to table it? Is that too many choices all in one question?
I feel like I'm ready to move forward on it.
Okay.
I can suggest a form of motion. We can see how it goes.
Okay.
There is a motion in the packet, but Kent, did you have something?
Well, Mary had asked a question specifically, and the language that's in the encroachment license says that as a general policy, it is not in the town's interest to grant encroachments, thereby granting public property to private use. So that's the language, granting public property to the private use. It doesn't really mention regarding STR in the specific policy itself. So that was the only thing I wanted to state. Maybe it's in a different location and Mary can correct me, but that's what the language that I had.
Well, before I call on you, Rob, Mary, did that answer your concern?
That addresses it
Okay.
somewhat. My interpretation of that would be that could preclude it from being used as a short-term rental if we're giving them access for private use, business, whatever. I don't know.
Yeah.
Okay, and just for my clarification, Kent, that was language from an encroachment agreement, not from an easement.
Correct. That's the procedure for reviewing encroachment licenses. It's the last part of the last bullet.
Okay, very good.
And I would tell you that you can certainly, as I answered earlier, you can engraft that policy onto this easement. You have the power to do that, and that's just part of this motion, and you put it on. But if you don't put it on, the policy around encroachments will not govern the use of this easement. So it's really clear to me that if you do want to have that limitation, it needs to be expressly upfront, approved as a part of this easement agreement, and then we'll enforce it. But it can't sort of slide in from the enforcement policy because that's, the encroachment policy, because that policy doesn't apply unless you make it apply, and you got the power to make it apply if you vote for it.
Okay. Yes, Rob.
Didn't they just say they don't have any plans on being an SRT?
Correct.
STR, sorry.
Correct.
I would imagine I want to waste a lot of time with a limitation that's never going to apply.
Well, never say never. I mean, they plan to own this property indefinitely. However, property can be sold, and this easement runs with the land, so it stays in effect. Whatever conditions are put on it at this time when we approve or disapprove, whatever it is, those conditions remain in effect. And if that condition is not put in there, then it doesn't apply.
So what are we afraid they're going to use that right of way for?
A short-term rental that would increase traffic and bring the kinds of impacts. Mary can correct me if I'm wrong, but I think that's probably where she was headed. That brings the kinds of impacts to a neighborhood that short-term rentals bring. Understanding that this would be eligible for a short-term rental permit in that district if there was, for the percentages, et cetera, there was one available they could apply for.
I bring that up, Rob, because our short-term rental ordinance is so specific as to how or where parking has to be for the short-term tenants, and it has to be on private property, and you can't just get your neighbor's permission to park on theirs, blah, blah, blah. And here we are giving access to, or we could be giving access and opening up a can of worms. Do you want me to go on? I think everybody gets it. I think.
Okay. Oh, it's like
that's just my concern.
Okay.
And Skyline Drive has a limited, access anyway, and we've heard from past board meetings when there've been improvements up there as to what, you know, the roadway use might be, et cetera. And so I'm just
Okay,
trying to look into the crystal ball.
got it. Right, I know.
How about adding a condition, no parking along this easement then? I mean, if you're worried about parking on the easement, just add a condition that you don't want any parking on that easement.
Under any circumstance?
It's just, you know, it would be just a travel road. Just no, you know, just like a lot of roads that have no parking signs on them. Just, that's what it would be. If I guess I could see Mary's point if there's a concern about having 20 cars or something going to the STR and they're all parked on this private drive. You know, you could be overloading the property. I think the STR language would kind of allow us to slow that down. But you could always just say no parking.
Or this is just a suggestion. If you, I mean, you could, I could foresee a circumstance where they want to hold a large family gathering and would want to be able to, for a specific limited period of time, allow parking along that easement. However, I could also see a restriction put in the easement agreement that restricts parking. No portion of the easement should be used for to satisfy the STR parking requirement. I could see doing that. And then that way the STR parking would all have to be up on the claim itself.
I could see our police trying to enforce that might be difficult. You know, something like that. If it's not just cut and dried, that would be my problem with that.
Also remember that, you know, STR permits can be issued with conditions. And often are issued with conditions that are site specific to that operation and are less hypothetical, I guess.
True.
So show it. I can suggest a motion, and then you can try amendments around parking and STRs and related items, but we can at least rope in the things I think that there's general agreement by the board. Up to you.
Okay. Is that agreeable to the board?
Yeah.
Proper motion would be to approve the easement agreement between the town of Georgetown and Justin Scott and Lycia, Scott, for a driveway access across the identified parcel of land owned by the town, with the following changes: that the width of the non-exclusive perpetual easement be 25 feet on either side of the center line shown on Exhibit A, but that the traveled width of the driveway be limited to 15 feet, 7.5 feet on either side of the designated center line. And secondly, that the town attorney recommended standard provisions requiring indemnification from the property owners to the town for any damage, injury, or loss to third parties be included in the easement agreement.
I'd make that motion.
I'll second.
And moved and seconded to approve the easement agreement between the town of Georgetown and Justin and Lycia Scott for driveway access across the identified parcel, with the conditions as listed by our town attorney.
May I ask Craig, and I'm sorry to do this, it seems to me the 15-foot traveled width might not exactly follow the center line. Depending upon how it's built, it might wander from the center line a little. I mean, it makes sense to define the 50 feet on center line, but I think maybe I've overthought this a bit. And a 15-foot driveway may well vary a little. You don't care. Your goal was that the traveled width be 15 feet. And if it makes more sense in a certain part of this driveway, that the cut and fill slopes, et cetera, need to be mostly on one side, they really ought to have that flexibility. Otherwise, they'd be doing more cut and fill than they needed to. Objections to that as kind of a minor amendment to the maker of the motion and the second are okay with that?
Yes.
Give Craig a little bit of flexibility in design. Okay. Thank you very much. Sorry to take you down that rabbit hole.
Okay, and that wasn't, who, didn't Paul second that?
Paul did.
Are you in agreement with changing the terms of the width?
Yeah, that's fine with me.
Okay.
Thank you.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion passes. All right, thank you. And go ahead. Oh, okay. Agenda item number 4 is resolution number 6, series 2021. A resolution of the Board of Selectmen for the town of Georgetown, Colorado, approving the final subdivision plat for the Washington Mills subdivision and in connection therewith, approving a subdivision improvements agreement.
Jerry's going to start us off on this one as well, Lynette.
Okay.
Board members, as you recall, you did approve this final plat after a hearing at your last meeting. And the purpose of this resolution is not to reconsider that decision in any way. You made that decision. The purpose of this resolution is to memorialize the evidence presented during the hearing in a form that's readable, hopefully. This is not the whole hearing, but it's kind of the Cliff Notes version of how that hearing went down, and memorializes that. And secondly, that it is designed to also approve the subdivision improvements agreement for the construction of the improvements that would be dedicated to the town or for the town's use. The water line, the water main, sewer main with their various manholes, and the improvements to Biddle Street, all of which are guaranteed for their construction by the subdivision improvements agreement. And I wanted to make sure that the board approved that agreement and then authorized and directed the police judge and town clerk to execute them. And that's the function of this resolution. Questions? It's kind of a pro forma establishing, memorializing the record, really, of what you did last meeting. I think there's a motion in the packet.
I can make the motion.
Okay.
I move to adopt resolution number 6, approving the final subdivision plat and in connection therewith approving a subdivision improvements agreement.
Second.
It's been moved and seconded to approve resolution number 6, series 2021. Any further discussion? All in favor, say aye.
Aye.
Any opposed?
No.
Thank you. All right. Thanks very much. Thank you, Marvin.
Appreciate all your work with helping us on this.
You bet. Agenda item number 5 is resolution number 7, series 2021. A resolution of the Board of Selectmen for the town of Georgetown, Colorado, reinstating shutoffs for non-payment for water and sewer utilities. Go ahead.
Please, please, Judge Kelsey and members of the board. This is a resolution we had put into place earlier because of the continuing effects of the pandemic and the hardships placed on residents and businesses. They had directed staff, the board had directed staff to suspend shutoffs of water and services for failure to pay. We're asking, or staff is requesting, and we had just asked about it at last meeting, to present a resolution in order to reinstate that policy, which is within our Georgetown Municipal Code. This is that resolution. Most of the people that we have right now on that would be on the shut-off list are pretty much consistent members of that shut-off list. It is not unusual people, and it hasn't grown to a larger number.
Okay.
At this point. It's pretty consistent. But in order to get some response from the customers, sometimes this is the method that we have to go to. We don't like doing it, but it is something that we have to do. And they are given notice on frequent times, but now we do have some customers, and Mary can probably elaborate, Mary Sims, that is, the town treasurer, and can elaborate as far as there are some folks that have not paid for months. And at some point, there has to be some restitution for using the service. And you can send all the notices you want, but all of a sudden, when you shut off the service, then all of a sudden they come up with an ability to pay for even a portion of it. And we work with people all the time if they communicate with us. But there has to be some sort of stick to change the behavior. And that's what this is about. I don't, Mary, if you wanted to elaborate any further regarding what this resolution is about.
Well, I mean, there really is only 5 to 10 customers that are these frequent flyers. And, you know, they know, oh, don't answer the phone when someone calls. And it's gotten to the point where they know we're not shutting off, so they just don't pay. And it's almost we're spinning wheels. And I always work with people. If there's a circumstance that something has happened, you know, we'll give them extra time to pay, or say, okay, we'll, you know, pay half now and half in 2 weeks, even if it's after the due date. I mean, we always work with the customer. So it's time, because it's not anybody new. It's not, the stories aren't that, you know, I lost my job or anything like that. It's just like, I'm not going to answer the phone and I'm not going to pay.
All right. Any comments or questions from the board? Yes, Deanne.
I could see this backfiring. I know a case of it in a whole other different state even, where the renters had their utilities turned off. They faked it through on electricity and all of that, but they couldn't take a bath or a shower, but they did continue to use the bathroom and filled the bathtub up, and the whole place reeked. It was a really bad situation. We don't want that. There's a real big probability that wouldn't happen, but it could. Is there some way we can get a some social entity involved that if they are given their final notice and haven't responded adequately, that then, I don't want to say the sheriff's department, but maybe one of the welfare parts of the state or county's government, or even the town's something, could go in and have a come to Jesus meeting with them.
If I could just explain something with our system, whoever owns the home is continually getting a bill, whether they have renters or not. So they can watch whether or not the renters are paying, if they're responsible. We're not in the business of being their property manager. So that, if the person cares about their home, the person that owns it, they're going to intervene and not let that happen.
Why hasn't it automatically gone to that level then, where the owner is the one in charge of paying, if the renter, because that pulls the town out of dealing with it altogether and puts the onus on the people who are involved.
It's not always the renter. Sometimes it's the owner of the house that is ignoring that they have this bill.
Well, then they need hit up too. It needs, I'm just concerned that one of our historic structures could get damaged by turning off utilities. I realize probably most of these are in some of the apartment-y newer places, like maybe down by the lake or over on Argentine Street or something, but
not necessarily. And all the apartments are all billed through the property manager. So it's one bill for all the new apartments. It's not individually billed. But the water bill stays with the property owner. So if they choose to rent their house and the property or the renters moved out and didn't pay the water bill, the property owner is still responsible for that bill.
I don't see how that changes anything.
Well, I'm maybe I'm not understanding your question. Either the property owner is either going to pay the bill or not pay the bill. And if we shut off utilities, usually that sparks them to, oh, I better pay this bill.
If there are renters on premises and the owner isn't paying the bill, I could see this turning into a problem. That the renters are still present, they don't have water, the owner isn't hurting. So, there seems to be, we need a lever.
I can understand the concern, Deanne.
Yeah.
I can certainly understand the concern, but the alternative for the town, though, to continuing providing service unlimited, is really it's not a good answer for the rest of the people who actually do pay their bill. Because then we have people who, out of 600 customers, we have 10 customers that refuse to pay. Do the other 590 have to have higher bills in order to carry the 10 that refuse to pay? And that's what eventually it will come out to be, because it just can't be unlimited.
It needs to go to where the source of the problem, most certainly. But it seems like perhaps if you could get social services to intercede, that, there might be, I realize one more step in brain damage and all of that, but it seems like
they do have that opportunity, and we have referred people at times to resources that they could check into. There's always that, and especially over the last year, there's been resources that have helped through CARES funding and through other, rental assistance and all types of things that has been available to people. And, we just have a small number of folks that have either chosen not to use those resources or haven't used it for this purpose.
Once
And
someone has a history of non-payment, can they be put on a probationary list so that if there is a second time, they aren't given any length of leeway at all, that, you know, they've got 60 days max or something?
you know, it happens fairly quickly, and it adds up pretty quickly. I mean, when we're talking about folks right here, and Mary can elaborate because she knows it firsthand, we're talking people who haven't paid for several months. I mean, it isn't just 1 month that the shut off occurs. There's notice of, it's trying to put that policy back in effect so that they don't get to a place where it just becomes overwhelming. You have to have some sort of stick to say, you need to take care of the bill, and and if you can't, you need to investigate resources in order to help assist you with that. And we can certainly refer people to possible places, but we can't carry their hand and, do it for them.
Yes, John.
I think when we established this program, it was a temporary thing in my mind, and that we were kind of trying to help people before the COVID benefits could be realized for themselves. I think that we've had this system in place forever, and I haven't really ever heard of any problems, other than kind of like maybe a rare thing or something. I think just reestablishing what we had is a good plan going forward. And if there's COVID stuff or social service stuff or whatnot, they can be referred to the correct agencies. We should just put back our old program.
So
I believe it is written in the code that we do shut off and after for non-payment, and we give 10 days notice prior to the shut off. The notice is mailed and it is posted on the property. I mean, they have plenty of notification, and like I said, if people have a circumstance beyond their control, we always work with them. So.
All right, any other comments or concerns, questions from the board? There is a suggested motion in the packet if someone would like to make it.
I move to approve resolution number 7, series 2021, a resolution of the Board of Selectmen for the town of Georgetown, Colorado, reinstating shutoffs for non-payment for water and sewer utilities.
I'll second.
And moved and seconded to approve resolution number 7, series 2021. Any further discussion? All in favor say aye.
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 Can I abstain?
Yes, I will ask for opposed, and then I will ask for abstentions. So
Well, one point I guess I'd make, Lynette, I'm sorry to interrupt you.
sure.
Board members, to abstain, you need to have some form of conflict, financial conflict, etc.
Okay.
Because otherwise, an abstention, with no pejorative intended here at all, allows board members to not do the hard thing, which is to vote yes or no on the stuff in front of you and the people elected you or you got appointed to do their work, and their work means being present and voting. Now, obviously, if you have financial conflict or some kind of prejudgment or personal family interest, then abstention is appropriate, but not on sort of a straight up policy question.
Okay, thank you, Jerry.
Yep.
Okay. So any opposed?
I am.
Okay, thank you. All right, we are on to staff items. Under COVID update, I'll just throw a couple of things out there quickly. You probably have noticed the 2 variable message boards that came into town about a week ago, a little over a week ago. And right now they are encouraging our visitors to be kind and everybody wear a mask when you're inside. And that is to go along with the county's mask and dial measures that were put into effect 2 or 3 weeks ago, and then they've been discussing modifications on a weekly basis, just as a replacement for the state requirements that have been dropped or will be dropped soon. So any other COVID updates that anybody has? Okay. In your packet, Kent and Jennifer provided the list of committee and commission appointments that we'll discuss further at a later date. We just wanted the board to be studying it, seeing what you might be able to commit to. The one change, correction that needed to be made to what was handed out was that Mary Smith is now serving as the board liaison to the Promotions Commission. But we will have some openings to fill as soon as we'd like to fill them as soon as we fill the vacancy in Ward 3. So just be thinking about where you might like to serve, and let Kent know if even if it's not an opening, if it's something that you're feeling strongly about serving in that capacity, please let us know. So so I'll let Kent introduce the variable message board's purchase item.
And there was some talk about purchasing the variable message boards were rented by the county for a month, as far as the 2 that are in town right now, as far as the COVID messaging or the county health update messaging. But I do have, was given information of a possible variable message board that had been purchased at a CDOT auction by a resident up in Silver Plume that our road and bridge supervisor knows. And I went and took a look at it, and I don't know if Jennifer can share the pictures. I don't have them up on my screen right now, but have an opportunity to purchase a variable message board for approximately $150. It would take a little bit to make the boards look a little bit nicer, but it is operational. But it's such at a small price. The one right before that, Jennifer, that's actually the typewriter and the code into it. But it is just like our current boards that are being used. And it's just on an older trailer. And it's still operational. So we hadn't really discussed about purchasing the, that's the solar panel on top. It helps to keep it charged up within, and it needs batteries out for it. But the board is very similar to what we have currently. And we seem to be using them every so often. And I didn't know if that would be of interest to the board that we actually obtain one so we wouldn't have to rent them. But
are they going to, is it $150?
Yeah, or that's what I was told. I don't
Seems like
have
a
anything to
no-brainer.
write it to that friend.
What do they cost to rent?
More than that for, I don't have that off the top of my head, Mary. It was a
Do we-
couple $1,000s for the rentals that they did for a month,
Do we
so
know what the batteries are to replace them in the solar panel or whatever?
they're down below, and they would be 4 different batteries, and they're just like regular car batteries, actually.
Oh, okay, so it's not like some pricey
No.
$1,000 battery.
No, super Tesla battery or something.
A light
It's
plug
not
to the
that.
sun.
No,
Okay.
no.
It
If
seems
it costs that much to rent them, it certainly makes sense to buy one if we're going to be using it that often.
it's the kind of thing that might help us down at the lake too, to have better messaging, when we're trying to say, stay off the non-ice.
Yep.
How much are they asking for it?
150, but I don't have that in writing, so it may change slightly, but
For
that's what I
$150,
have.
that's it?
Yes,
Is it
sir.
negotiable? No.
I
Kent,
mean,
were you able to find out an answer about whether or not they can, like be turned off at night if it's not, so it's not a upset to a residential or a business area, after hours kind of thing, wherever it's used? I mean, I could see potential when we've got activities going down on 6th Street too, that we would want to encourage people to come down there. But, after 10 o'clock at night, no one's really, or 11 o'clock, maybe nobody's really looking for it. So can they be programmed like that?
I believe they can, but I don't have 100% confirmation of that.
If you can get this board, you can find out, right?
Yeah.
That's a negotiable factor then, I mean, if it can't be turned off, we got to run over there and unplug it.
For
We gotta go
$150,
put a
how
cover
can
on
you
it.
go wrong? I mean,
Yeah.
$150.
Yeah.
I mean, I think you're going to get $1,150 out of it.
Yeah. The newer ones are much more expensive. So. Yeah, the batteries will end up, for 4 of them, end up 600 or so. So
it's still going to be a lot cheaper than, so when the company that these are the current ones are being rented from, did say that they could be purchased if we were interested, but the cost is going to be significantly more. And I think we get
it was multiple thousands of dollars. Yeah.
Yes, several. So, and currently they're being rented with COVID relief funds. The county is paying for that, but I don't think they want to continue they've got 2 boards in Idaho Springs, 2 here in Georgetown, and 1 at the vaccination site. And I think they don't want to continue to rent those on an ongoing basis. And so if we are interested in purchasing either the ones that are here, but I'm much more interested in purchasing the much more inexpensive one. So I would give Kent a thumbs up on, spend what you need to spend as long as it doesn't exceed $2,000 for the purchase and the refurbishing. Does that seem reasonable?
Seems reasonable.
Okay.
Yeah, I agree.
Okay. Do we want just 1 board?
That's the only one available.
Oh, okay. I didn't understand that. All right. Very good.
The other thing I was just going to say, and just a considerable point, if there's a deep need for these in the future, and we can't get one because they're sold out, we still have this one, and we can also rent this one out to somebody if we don't want to use it. So it could be a moneymaker.
It'd be part of the special events permit, when other places come in, they could rent our message board for
True.
Yeah, make it a package deal.
Yeah.
Great idea.
True.
Are all the parts accessible to get? Like I'm thinking, does it have specialized light bulbs?
I didn't look at the light bulbs themselves, but they are fairly easy to replace on the other boards. So I would expect this one not that much different. So
It's like for $150, you wonder what the catch is like, yeah, is it like $2,000 batteries, or is it exotic bulbs, or is it the light switch comes from a small town in Germany, that kind of thing. Just don't want to be surprised that way if you buy it. That's all.
True. Okay. Any other comments on this? Are we ready to move on to bollards? Okay.
bollards, I don't have much information. It's more tied into maybe something to discuss a little later. I have a couple quotes. I'm waiting for a couple others as far as bollards for the downtown 6th Street to be able to close off the street. And I'll have a formal proposal instead of just a staff item. I guess mainly the staff item, we had discussed it during budget, but I just want to make sure that you're still okay with me pursuing that and having that proposal presented to you.
I personally think it's a good idea to keep pursuing, first of all, because it's going to provide more safety than we pulled it together last year with temporary barriers that were an upgrade from just the sawhorse kind that we used to use for closing off the street for events. So I think I'm in favor of making a more secure and better looking method of blocking off the streets when it's needed.
Okay. And most of them it's not a long lead time for actually purchasing it. So as far as if there's concern regarding when it would be available. The other thing that, and it'll probably be discussed in the promotions meeting next week, is what would be the interest in when they would be used to shut off the street. I don't think there's as much, and you guys can tell me something different if you have a general inclination one or the other. But there doesn't seem to be as much of a general inclination to shut down the street for a long time period. To still have the ability to shut off the streets for special events or for weekends or, certain special things, and especially for Christmas market when it occurs, but not for a longer term situation. And if you don't want to say anything about that right now, and or if you do, that's fine either way regarding that general inclination. So
okay. Yes, John.
One of the fire chief was concerned about the ability to get them out of the way for emergencies and whatnot. So whatever design you're looking at, might want to make sure that padlocks can be cut off and they can be thrown off to the side.
Yep. Absolutely.
Okay. All right. If there are no more comments on that at this time, we had a request from Joe Negus's team. He's our representative at the State House to sign on to a letter that will be sent to the president to encourage and support efforts towards addressing climate change. You had the letter in your packet. Any objection to the town signing on? Strong feelings for or against? I see a thumbs up from John, thumbs up from Mary, Rob, thumbs up from Deanne. Okay. Unanimous. We will offer our support then. Thank you. We have Cindy Neely joining us tonight, and she's going to talk about the capstone project.
Oh, actually, I
Sure.
would like to talk about two things, if that's okay.
Absolutely.
The first is, as I think you has been reported to you, we have secured some funding for putting the bikeway in along Argentine Street from 11th down to Loop Drive. And partial $100,000 of that funding is coming from one of the most interesting little pots of money I have seen in a long time, which is a governor's program done through CDOT, and it's called Revitalizing Main Streets. And the Revitalizing Main Streets program is specifically for small towns to do things for pedestrians, bicyclists, and to literally revitalize on downtown areas. And in working with the gals who are running that program, well, first of all, it was astounding. I mailed in, or I electronically sent in our application for the bike path on a Monday. On a Friday, they told me we had it. I mean, who's ever heard of a grant turnaround like that? I mean, it was crazy. The next thing they told me is that they had upped the level that we could ask for, and wouldn't I like to ask for double what I put in? And they again said yes. And we've already have the shortest contract I've ever seen. It's sitting on Mary's desk. In the process, what they told me was that each town or each grant recipient could get up to $250,000 in grant requests. And so when Kent was talking about bollards, if we wanted to look at doing not only bollards, but some street furniture, I mean, it is my presumption that the picnic tables I'm looking at every day when I walk to the post office came out of City Park, and that City Park probably needs them back at some point along the line. And if we wanted to look at some smaller scale furnishings, it might make a really, really appropriate kind of request to these folks, because the cap for any given agency is $250,000. And just because they've given us some on the bike path does not mean they would not consider giving us some more for the purposes for which they were created, which is revitalizing downtown. They have sponsored street furniture all over this state at this point. So this is the most common kind of grant they give. So I am sort of asking the board whether you want me to go ahead and investigate that a little bit and see whether they seriously would get into this subject with us, because it could be a nice way of, I don't know whether, I'm not trying to design the thing. I'm trying to fund something that's not yet designed, but I think that we all know that some tables and chairs along that main street would be people would use them. And actually through the summer, the picnic tables are probably too big because they are sort of, tend to block as long as they have to be on the sidewalk, they tend to block it a little bit. So I guess my question number one is, shall I continue on this investigation or shall I not? That's quite my question number one. And then I'd like to talk about capstone.
I could see getting some old-fashioned looking benches, but I don't think tables are a good idea.
Well, I'm not trying to design it at the moment. I'm just trying to ask these folks whether it is something they would consider. The design. If they say yes, then we'll talk about, what are we actually doing?
Yeah.
But if they say, no, they don't, either they're coming short of money or they need to die, they'll be very honest with me whether they think we have a good shot to get money. So
Go for it.
Go for it.
Yeah, Cindy, it's a great idea. We'll figure out what to use it for if they say yes.
Yeah, yes. I mean, we don't have to super define it. Street furniture can be sort of street furniture, chairs and benches, tables and I don't know, I think that it may not be timely enough to pick up the bollards because they certainly have done bollards all over the state. So I think it's worth the question to them. Okay, I will go ahead and make that question. The other thing that came across, people keep sending me things like, you could apply to this, you could apply to that. But Colorado School of Mines has two programs, which are programs for their graduate school major study, major, basically almost an intern experience, but they're not interned. It's corporations, nonprofits, and governments can apply to the school to have either a semester or a year-long technical problem that will be undertaken by a group of students who are supervised very closely by faculty. Some of the things that they have done are just sort of outstanding. They're staggering. Some of the projects that have come out of this, the fee for industry to get this happen is $5,000 a semester. The fee for a nonprofit to have these students is $500 a semester. The fee for government to ask for a student project like this is zero. It costs nothing. And my thought was that, and when I looked over the kinds of projects they've done, there are a number of projects that have been done in the past on drainage. And we have old drainage plans, but we don't have anything that ever even took one of those plans and said, okay, this is what you specifically need to do to make it work. We have plans that show you where your problems are, but not where your solutions are. And that it might be a really, I don't know that we have anything to lose by asking, putting in an application for a capstone project, which is a 2-semester project. And the reason I say that is because we want it to go through the period of time where we melt, so that they can see what the drainage is, what the problems really are, and that we probably can't do the entire town, but we would decide on what section. I also felt that building a connection with mines has advantages, to get to know who to call up when you might have a difficulty with something. So that was the other one that I'm certainly willing to, put together a little proposal for them. They're due in on June 1st, I believe, July 1st, somewhere right in there. So I'm asking for permission to try to get free labor.
I think it's a great idea.
Does Georgetown have drainage issues?
No, none.
Front of your house.
Not on your block, Paul.
It's right out front.
Them all.
Can't get to his house.
Didn't you notice that this morning when you walked out the door? But of course it's spring, so it was real easy to come up with a project idea for this.
Yeah, I'm for pursuing it, yes.
Yes.
Okay. Thank you. We will pursue on both levels. And I think that Kent has told you there's going to be work done on the streetlights on the roundabout, and they've scheduled it for, provided they get the bulbs, they've scheduled it to start the work of May 10th, which is good. So we would be, as we come into our hopefully much busier season, We are,
They're changing them over to LED lights.
yes,
So it isn't just changing the bulbs on it. So
no.
there's a little bit of work on the lights.
Yeah, they had, when they were originally put in 10 years ago, they were induction lights, which is not, and at this point, they'd be much better off to be LED, but that means you have to sort of rewire so you bypass the ballast. So you can, so they will do all of the lights for the roundabout and all the way down to the 11th Street. They will not do the new lights from 11th to Loop yet. I'm not saying they'll never do the new lights from,
Cool.
I have a problem with using LEDs because they're just too bright. I literally have to put on sunglasses at night on that one section of Argentine.
yeah, well, we agree with that on that one section. What we're doing, and that's why I'm really interested in seeing the bulb. Ultimately, Deanne, if we don't like these bulbs, we can unscrew them as bulbs and put in a different bulb, which is a whole different thing than what we've got going on from 11th Street to Loop.
Yeah.
And so we want these outfitted in this way so that it is easy for our own guys. The other thing is that they will have a diffuser, which is not, there are no diffusers.
There won't be hot spots.
The bulb fits up in it, and it's a diffuser, and it's a different Kelvin. It's a different color. So we're going to see how those light bulbs work. But if we want to tone down the light bulb, we do it the way you would do it at home. You unscrew the bulb and screw in a different bulb, which is something we can't do to the new lights. That's why I say we're going to do it up to 11th Street, and then we have decisions to make about what we want to do with the lights that are too bright.
Another comment on the lights that are too bright. I was walking on one of those bohingiously windy days in January, and yeah, the bell-shaped covers are so wobbly that they'll blow away pretty soon, you know.
At some point, yes, yes, there are problems. We know that. We're coming down the street at them.
Cool.
Okay. All right, anything more on the streetlights?
Not for me.
Okay. All right, that ticks those off. Looks like Strauss Park tree.
Yeah, and I've had proposals from 2 companies. I haven't had our tree in Strauss Park, or actually both of them are not doing very well. But the one, the evergreen, half of it is dead and it's proceeding to the other half. It splits into about 10, 12 feet off the ground. And it continues up, and the half that's towards the east is dead. The half to the west looks alive, but ended up getting, and it said something previously, we were eventually going to have to look at this, but and let me share my screen real quick. And it ended up getting a couple different proposals as far as taking down the tree. The problem that Bear Creek Cherry Service had given me a quote of $3,600 and $36.75, and the Lamb Tree Service gave me a quote of $28.45. We use both tree services for different services within town. We use Bear Creek on a regular basis for cutting down the trees and the trees that are not. And we still have a couple more to do within the parks to take out trees that are dying or are a problem. I want to be able to see you. Sorry, I stopped my sharing of my screen. But I'm also looking for a from both tree companies for the ability to replant with something else that will survive. And that will be a very decent sized tree. And that, as far as the Strauss Park tree, I almost diverted into a tangent issue. Sorry about that. Dan, you got an immediate question or?
How about the one in the library park? Because it's ill also. Is there a way they could take all of them at the same time? It seems, as long as we're going to have a bad haircut, we might as well go for it, you know?
I was intending to pass along the information and contact the library director. I had not made that contact as far as for their thing. And John, you may have something regarding that.
Yeah, we're aware of the trees, and you know, we're going to pay to have them come down. I don't know about the timing, but
to be able to coordinate, and either company could coordinate with the library board to get that one taken care of in library park as well.
I talked to Libby today, so I'll talk to her about getting together with you about your trees. And maybe they could all come down at the same time. That'd be good.
Right.
Get a bulk discount.
But trying to find a tree to replace it that's within the same time frame, and want to coordinate the timing of it. Originally, I had talked with one of the companies about being able to do it in a couple weeks or at the end of next week, and then being able to replace it within a week after that, and they were more than willing to do that. The problem is that the replacement tree is not the size that they had really originally talked about, because I warned them about trees and what I've been advised here as far as trees that come up from the metro area don't have a good history of surviving. So, especially larger trees. So don't want to get in a situation where we plant a larger tree and then that one's dead within a year. Now they'll guarantee it for a year, but that doesn't mean, you know, that'll survive long term. So, Dan.
At the county commissioner meeting today, they ended up with a whole big, like at least an hour on fire mitigation being pretty severe and pretty important. Seems like there should be some sort of win-win if we can pick up one of our own big trees up Fall River Road that needs to be cut down. If it isn't, you know, I mean, and bring it over here, it's already going to be acclimated to high country, you know.
It would be acclimated to high country. The problem would be trying to remove it from its location, because it's a pretty large piece of equipment, moving those trees. I mean, it isn't a small piece of equipment. So, and whether you'd have permission to do that or not, but there'd be other things involved with it. But go ahead.
I'd like to see a big notice go up, maybe tacked to the end of the green booths, the 6th Street end, that explains all this, because if people just come walking past one day and it's not there, or come back past and there's big chainsaws out, they're going to be upset. We got to let everybody know at least 2 weeks or a month or so ahead of time, because otherwise it's not fair. It's the, you know, somebody's got cancer, you want to have time to say bye to them.
Yeah. Yeah. And you had a suggestion earlier. We did put up one sign, but it needs to be more prominent as far as letting them know that the tree is going to come down. We didn't have an exact date. I won't have an exact date till I know that the other tree is coming, because don't want to leave it bare. So, but I wanted to, and that's why I wasn't able to put it in the packet, even though I had most of the information. I didn't have all the information, but I wanted to let you all know that that's the approximate price to take down the tree and working. You guys can't see that. I haven't shared my screen again. I don't know why I'm waiting for some sort of response, but I've been able to get a couple. And in addition to that, I've talked with those companies, and I need to make sure with Lamb Tree Service that they, you know, Promotions had brought up the idea of being able to slice the tree and being able to have people obtain slices of the old Strauss Park tree. Bear Creek, I know because I talked directly with the representative. Need to confirm that with Lamb Tree Service, but Lamb Tree Service had the better price for taking down the tree. So I just let you know that. And then are you okay with staff direction to pursue getting that done? I guess.
I would just ask, I had a question for you, Kent. So,
Sure.
both of them have done work for us in the past. I think, do the prices that they've quoted include the stump grinding and removal? And okay, and when they grind it, are they hauling off the chipped material?
Yes.
Okay, because there's been some variation in the past on that particular.
Making more work for us. Yeah.
Yes, that,
That's not good.
Piles of chip from the stump grinding got left in City Park. So just making sure that it includes the whole removal.
Right.
Yes, Deanne?
Is there any chance that we should leave it empty for 6 months or something, that the new tree would catch whatever killed the old tree? You know, do we need to sterilize the soil or something like that?
I don't think that's going to be a case, but I can confirm that with the tree companies. So I don't think that that's a possibility, but I can confirm that with the tree companies.
We also do a regular spraying of the Engelmann spruce that's in City Park, and I don't know if adding the new tree to that spraying program would prevent the
Whatever, yeah.
yeah. It was Ips beetle from my recollection, and just offer that as a possible mitigation.
Okay.
Does any of the improvements that are proposed for Strauss Park, would that impact the growth of the new tree? Because that could be a concern as to when we replant.
No. Because the tree is going to be ending up in the same spot as far as the design of that, or pretty close to the same spot. We won't put it in the exact, I mean, it'll be a few, just basically the size of the trunk over from its current location.
I realize there's no construction there, but any of the construction that's in the surrounding area could potentially.
Yeah, it could potentially. We did make comment that the other tree needs to come out as well, the cottonwood that's on the south side of the park. And that won't happen until the actual project to replace the booths are put into effect, because that will be affected. That's too close to where construction traffic would actually occur.
Okay.
The evergreen is far enough away from the booths and far enough away from the fire pit location that it will not be affected.
I guess I would just, recommend protecting that root system from being driven over by construction vehicles during the refurbishing of the park. Just it's the tree's going to be struggling to establish itself, and in order to make sure that it survives, we should protect that root system.
Absolutely.
So
we can as much as possible.
Yes, Deanne?
First is why aren't we focusing on doing the park stuff down at the lake and leaving Strauss alone for a bit? And second, a tree is going to need guy wires with the wind that goes through there. Where are they going to go? Because it's going to need a lot to keep it up until the roots are good and established in couple years, you know. It's gonna have to have real solid guy wires, bracing. You can't just sit it back in the hall, you know.
Yeah, there will be, but it's the tree staking, it won't be that far. I mean, it's not the height of the tree. Trying to get a tree that's 20 to 24 feet high will be about 4-inch caliper. The staking for that is, it's not going to be a guy wire like you would see on an electric pole or something like that. Now there will be staking with it, and it'd be staking on all 4 sides, but
When the bank built the drive-up thing down in Idaho Springs, they put in several trees. Most of those were only about 15 or 20 feet. They were smallish. And they guide them out because that's how you keep them up. And the wind broke the tops off of all of them. So we're going to have to be real careful about that. Because there are all these short Christmas trees there. This first year, you could use the drive-up bank.
sure. Yeah, that is a concern. The taller you get until it's established, there's lots of things that can happen to it that can damage the tree. Absolutely.
What about, why are you aiming at doing Strauss Park rather than down by the lake?
I'm aiming as far as the Strauss Park tree, it cannot,
No,
I
not
mean,
the trees, the whole project, because there's enough conflicting stuff going on with Strauss that it seems like maybe it should just sit for a year. We have another Christmas market and work on things over the time, as opposed to right now down at the lake, you've got all kinds of problems with not enough cops to keep everything under control and too much trash.
Sure.
And people ignoring and or stealing signs and all of that sort of stuff. So it seems like that should be the focus insofar as park changing is, and that, yeah, get the tree established and then worry about doing any changes in a while.
well, as far as the Strauss Park project, I'm just trying to finish up what we've budgeted for and have had plans in place, trying to get those done, and trying to get those approved. And I'm just trying to finish as far as those plans. Now, as far as implementation of those plans, there will be decisions that will be brought to the Board of Selectmen, and there can be decisions made regarding that, and there can be direction given to staff to do it or not do it. That's, the Board of Selectmen's prerogative, but I've been given direction from board members through our, the processes that have happened over the last couple of years, and to get these plans done. So that's what I'm trying to do, is get those done. When those are done, then there's additional decisions to be made. And staff will follow whatever the board as a whole gives direction as. So that's what I have to do.
Okay. Any other concerns for anything else on the board, from the board? If not, I would entertain a motion to adjourn.
I'll make that motion.
Second.
Been moved and seconded to adjourn.
I'm too slow.
That's okay. You'll get faster. All in favor, say aye.
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 All right, that looked like anonymous. I'm not even gonna